A contracting officer shall not knowingly award a contract to a government employee or to a business concern or other organization owned or substantially owned or controlled by one or more government employees. This policy is intended to avoid any conflict of interest that might arise between the employee's interests and their government duties, and to avoid the appearance of favoritism or preferential treatment by the government towards its employees. Special government employees performing services such as experts, advisors, or consultants, or as members of advisory committees are not considered government employees unless, in the individual's capacity as a special government employee, the individual is in a position to influence the award of the contract, or another conflict of interest is determined to exist. The agency head or a designee not below the level of the head of contracting activity may authorize an exception to this policy only if there is a most compelling reason to do so, such as when the government's needs cannot reasonably be met otherwise. In the matter of metro offices, the protester challenged the agency's award, alleging that the agency improperly awarded the contract to a company substantially owned or controlled by a government employee in violation of Federal Acquisition Regulation 3.601. The agency asserted that it did not violate this provision of the FAR because the contracting officer did not know that the owner of the awardee was a government employee until after the award of the contract. The GAO found that the record clearly established that, prior to award, the contracting officer was not aware of the awardee's employment with the Office of the Undersecretary of Defense. According to the GAO, the contracting officer could not be said to have knowingly awarded a contract to a firm owned by a government employee. In addition, the GAO noted that Metro's supplemental protest on this issue was untimely. According to the GAO, Metro was provided with a copy of the proposal and thus became aware at that time that the awardee's owner and managing member was a Naval Reserve officer. Because Metro did not file its protest alleging that the contracting officer had reason to believe the awardee's owner was a government employee and that the award would be in violation of the FARs within 10 days of discovery, the GAO dismissed that portion of the protest.